From HP Ranina now. He's of course a Supreme Court lawyer. He's joining us on the phone line. Mr. Ranina, thank you so much for taking out time for us. Could you first start by the Essar issues? Ruia's 54,354 crore settlement plan for Essar is not maintainable by NCLAT. What do you make of that?
Well, that is a decision which Essar made challenge in the appellate court. But as I see it, I've not read the order at all, but what justification they have has to be seen. In my opinion, this order seems to be on the right line, because the basic principle is that, promoters who have been responsible for bringing the company to a stage of insolvency should not be given an opportunity once again to, bid for it after all the processes started, IBC processes started. Because otherwise it would completely undermine the very purpose of having this legislation.
Right. Mr. Ranina, I just want to understand, there's been a lot of back and forth, a lot of twists and turns in the Essar Steel case. Now, earlier this month, SBI also put its, loans on a block for auction. Then this development came by last evening with respect to NCLT passing an order against, or rather in favor of ArcelorMittal. How do you see, the whole issue play out going forward? Of course, NCLAT is the next option for the Ruias, but what is the likely outcome that you are expecting, and what does it say about the IBC process at large and the chinks and the loopholes that it has been exposed to?
Well, I would not say what it says about the IBC process. I think the IBC process is a very good process. It has a lot of integrity in it, but the difficulty is about the individuals involved. You see, the problem, as I said, is that these promoters, when they have the opportunity to come up with a scheme, they don't do that. And then after a lot of water is flowed down the river, that they start coming up. It is this which is very upsetting. That, I hope the Supreme Court will put an end to this once and for all, though they have already done it last week. But this matter has to be set at rest, and those promoters who come up with the scheme later on have to be, told that you can't just do it. And not only that, but heavy cost should be involved on them, because, you keep on going in for litigation. And this is why I think India is getting a bad name. That today foreign investors feel that they can't get involved in this country because somebody other is going to take them to court, or some thing is going to happen which will slow down the process. So it's a very, very unfortunate situation which has developed over the last few years, and I think the time has come when India must show that they mean business and they are not going to put up with this type of attitude. So the courts have to take a very strict view in these matters and have a levy costs to these people who go on litigating all the time, because they know that they will get away with it and they'll only delay the process.
Right. When we talk about the jet issue, now the latest news flow is that SBI may convert the loan and bring about 15% stake in the company post that debt conversion. Do you think that's the way ahead for a lot of companies?
I think so. I think the best thing to do is to convert debt into equity, because that's the only long-term solution. You have to bring down the interest burden. Every airline, whether it is Jet Airways, whether it is Air India, they are all settled with interest burden. So unless you convert the debt into equity, you can't get out of the gridlock. And that is why I think it's a very good measure which SBI is proposing to take, and I hope it goes through without any hitch.
Right, Mr. Ranina. Thanks.